what I want to do in this first video is have a look at the nature of a constitution. So we're going to be talking quite abstractly about the kind of things that make something a constitution, defining what a constitution is, and then starting to look at really what constitutional law studies, and then looking at the differences, but we're very briefly looking at the differences between a constitution from a country like the United States and a constitution like the one that we have in the United Kingdom. So as an introduction, we're going to talk about what is a constitution. And a constitution fundamentally provides the principles that form the governing framework of an organisation. Okay, notice here that this is a very broad definition of a constitution. We're not talking specifically about a state, about a country. Any organisation can have a constitution. Okay, so an organisation, like various things like companies, societies, all these kinds of things, okay, have constitutions or can have a constitution. And the purpose of these constitutions, in the broadest sense of the term, is they enable an organisation to run effectively. That's the first one, okay, and they also prevent those in charge of said organisation from abusing their power. Now, as you can imagine, this is particularly important of states. So this is important of states. And of course, the reason why is because the organisation of the state is something that's very important to the daily lives of everybody who lives in that state, okay? And these principles apply to a constitution of an organisation as small as, whatever you choose to organise, okay? And they grow, and they are the same fundamental principles, the same fundamental purposes that you would find in the constitution of a state, okay? Our UK constitution enable the organisation, the state, to run effectively, and it also prevents those in charge from abusing power. And that's the same of the French constitution, the United States constitution, so on and so on. So really, what does constitutional law then study? Now we've looked at the very basic, very meta principle, okay? So this is a very broad principle, a very broad definition, okay, and is a very meta definition, okay? It applies to just a general understanding of what constitutionalism, the idea of a constitution, really means. But what does constitutional law specifically study in this context, okay? It looks at and deals with a number of issues, of course, and these are some of the issues that constitutional law studies. We can't exactly define in one single term what constitutional and administrative law studies specifically. We couldn't define that in a very small, brief sentence, compared to something like criminal law or law of the European Union, where we can describe what these things study in a lot more, quite briefly. With constitutional law, it studies a number of different things, okay, including things like the choosing and removing of leaders, so election systems, so elections, for example, the relationship between each branches of government, okay, so things like the relationship between the government and between Parliament, okay, or if we're talking about the United States, notice we'll be comparing, in these early introductory lessons, we'll be comparing quite closely with the United States, because they are so almost polar opposite in terms of the nature of the Constitution of the United States with the United Kingdom, that it's very good to compare the two. And so if we're talking about the relationship between branches of governments in the United States, we could talk about the relationship between the President and the Supreme Court, or between the Supreme Court and Congress. Okay, these are the type of things that are that fit into this idea of the relation between branches of government, okay? A constitution also looks at and defines the relationship between the state and international bodies. Okay, by international bodies we could be talking about something as things such as the United Nations, okay, the United Nations, the European Union. We could go on and we can go on and we can go on, and the ways in which our country, in which the United Kingdom operates within these international institutions and international bodies are things that are arguably constitutional in nature. They also look at studying the division of powers within the state. Okay, now this doesn't necessarily mean just the divisions of powers horizontally, and by this I mean the divisions of powers between the three branches of a government. Okay, so for example, like the Parliament and the Prime Minister and the Supreme Court. It could also be talking about the division of powers vertically, so horizontally and vertically. So not just the powers between the branches of government, but also the powers that are separated between the government, say in Westminster, and the governments of devolved assemblies. And going even smaller, we could talk about local government and local councils and how the powers are shared between all these three almost levels of government. Okay, and we'll be talking about the idea of federalism as well in a later lesson, and how that's a terrible underline. There we go. And how the United Kingdom has a very complicated relationship with the principles of federalism, and I mean that's a question for another video. And then finally, just to note that these are not this is not an exhaustive list. Okay, there are other things that a constitution and a constitutional law would study, but the fifth major aspect of constitutional law is the relationship between the state and the people. Okay, how the state and the people operate within each other, and this really is a very fundamental principle when we're talking about issues of human rights, and we're talking about elections as well, how the people are involved in the choosing of state, in the choosing of parliamentary representatives, etc., etc. These are the things that we will look at when we talk about the state and the people. We also talk about things like police powers as well, and the way in which public order legislation operates within the United Kingdom. So these are but a few major themes within constitutional law. Before we finish, I want to talk a little bit about constitutions around the world, specifically the constitution that we have, and comparing that to the United States Constitution, because the two are very, very easy to compare and contrast, and it's just very simple to pick these two apart, because they are almost very in some aspects they're very polar opposite. So in almost all countries, the constitution is made up of a single written document, okay, and it is said to be set above all other law, so it's seen to be higher law. Okay, higher law, and we're going to talk about all of these things in a lot more detail in later lessons, but we're talking here about the idea of it being above the ordinary written pieces of statute that is created by legislature. Okay, and the example we can use is the United States Constitution, which is found in a single document, or at least it's all written down into one place. With the United States Constitution, you do technically have the US Constitution and its 27 amendments, or the US Constitution, its amendments, and the first 10 of its amendments, which is the Bill of Rights, and also the Declaration of Independence. These are all different documents, but could all be collectively put together as part of the Constitution. And this is why we argue that the US Constitution is codified. Okay, it's all written down in a single place, and it's usually, all being written down in a single place, every aspect of the Constitution every bit of law that you would call part of the Constitution is written down on a document, and that is not the case in the United Kingdom. So that's just something that we should keep in mind when we're talking about constitutional law and comparing the two different systems. And again, yes, it represents some kind of higher law, and this usually means that by higher law, by some kind of setting the Constitution apart from other legislation that is created by by statute, this usually means that there is some special procedure required to amend it. So for example, to amend the US Constitution, a very special procedure and almost near universal consensus is required to make the amendment, which is why there's only ever been 27 amendments to the Constitution of the United States. By contrast, though, the United Kingdom does not have a written constitution. It's argued, when we look at the sources of the Constitution, there are parts of the Constitution that are definitely written down, that are definitely, codified, but the Constitution, the whole Constitution itself, is built up from a number of different things, from judicial decisions, from common law, from statute law, from constitutional conventions, from works of authority, until very recently from the law of the European Union had a very big impact on the Constitution. So as you can tell, the Constitution of the United Kingdom is very different to that of the United States. And a great deal of content will be dedicated to develop our understanding of the UK Constitution and comparing it with other forms of constitutions around the world. And before we finish, I want to talk about the argument that, in fact, the Constitution, because it isn't written down and because it is so broad in the United Kingdom, that some have argued that the UK doesn't even have a constitution at all. Okay, and so some have suggested that in any kind of meaningful sense that the UK doesn't have a constitution. At least semantically, they may not be arguing that the UK doesn't have a constitution, but in any kind of meaningful sense, okay, that's what's important here. And an example of this would be the democratic activist Thomas Paine in 1737 to 1809, who labelled the British government as, quote, power without right, okay? And in his work, The Rights of Man, Paine argued that without any kind of written constitution, authorised by the people, there is no valid constitution. So in the United States, you would argue that the writing of the Constitution was done by the consent of the people following the Revolutionary War. In the United Kingdom, the Constitution is something that has developed over literally thousands of years, and some aspects of the UK Constitution, dates back to Roman law, and so it's very difficult to argue that that our Constitution is in any way or has ever been at any single point authorised by the consent of the people. And according to Paine, this means that if it's not written and if it's not authorised by the people, it's not democratically legitimate, therefore it's not a valid constitution. And despite this debate surrounding whether the UK has a constitution or not, there definitely is merit to the ideas of the constitution in the UK. So we will be trying our best to put this on hold, these arguments, because these arguments tend to fall into the more philosophical, political realms where we are talking about democratic legitimacy and these things like and social contract theory and all these kinds of things. So from a strictly legal standpoint, we're going to be assuming that Thomas Paine here is incorrect and that the UK Constitution does exist, and it exists in the form that we know it to exist, as an uncodified entity with numerous sources. So in the next lesson, we're going to look specifically at the UK Constitution, and we're going to be looking at the major principles that underlie the UK Constitution. And then in later lessons, we're going to be picking apart each of these principles and looking at really what they mean, and looking at different interpretations over the years of each of these different principles.